Ladies and gentlemen, our next panel is going to grapple with some of the legal issues, if any, associated with hybrid threats. And you might have seen on our poster, after hybrid threats equals hybrid war, there's a question mark because I think, or hybrid law, the question mark, does it really change the law? Is there a need? And particularly in the area of the law of armed conflict. I'm particularly pleased that Colonel Adam Oler from the National Defense University is able to moderate this panel. Adam's bio is in the book. Adam had the horrible experience of being my executive officer when I was on active duty. And before he was my executive officer, his lovely wife, Kate, was my executive officer. And that occasioned, I need to tell the story, Adam, because this happens to be one of the true ones. But we were in Iraq. I was doing a grip and grin going through, and we're talking to a bunch of Army officers, and everybody's going through introducing themselves, and get to Adam, and Adam said, I'm Lieutenant Colonel Oler, and I'm General Dunlap's executive officer. And right then I interrupted him and I said, yeah, I made him be my exec because he got the last one pregnant. And right at that split second, there was a mortar attack. So there's sirens going on and, chaos for about 20 minutes. Then when we got back together again, I just proceeded on. And Adam was telling me he's walking out of there and all the Army guys are gone. Not knowing, of course, the rest of the explanation. One of the wonderful things about this conference is you get to see so many old friends. And one of the people on our panel, Dave Graham, Dave doesn't even know what's behind him right now. That was from 1998 when Dave and I were on active duty and at the PACOM conference. And I think that's some Chinese general, as I recall. That's our story, and we're sticking to it. That's all we know. But without further ado, Adam?
Thank you. Well, good morning, everybody. The rest of that story is that while the Air Force guys or the Army guys were kind of smiling, some of the Air Force people were like, you careerist SOB. It was, and the other thing, I was General Dunlap's exec for 2 years, and I tell people the reason I got picked is so that when he yelled out, Oler, get in here, somebody would still show up. So it was a great experience. All right, well, let's, if I can, turn right to the questions. Panel, building on Professor Anderson's keynote address that we just heard, what in your view is hybrid warfare and what unique legal challenges, if any, does it bring? And sir, we'll start with you.
Although Charlie has flashed it on the screen, let me reemphasize that I'm here in my personal capacity, and I certainly don't purport to represent the views of DOD, the Department of the Army, or the Army's Judge Advocate General's Legal Center and School. So, with that disclaimer out of the way, I think it's interesting to note that the first couple of drafts for the agenda for this conference had this panel entitled Law of Armed Conflict in an Era of Hybrid War. And you see now that the title of the panel is The Law of Armed Conflict in an Era of Hybrid Threats, a change in terminology there from hybrid war to hybrid threats. And I think that's a very important change and a very telling change and hopefully a very deliberate change. Now, why do I say that? I say that because I think we need to be very careful about using the term hybrid armed conflict and hybrid war, if in fact, in using those terms, the intent is to reflect a completely new type of warfare, and Ken Anderson touched on this, a novel form of warfare. Because if that is the intent, I really think that that takes us down an international law, a law of armed conflict rabbit hole that we do not want to travel through. Now, why do I say that? I think if you accept as valid the premise that there's this completely new form of warfare, a novel form of, quote, hybrid armed conflict, You then have to say, well, then, is this new hybrid armed conflict being waged by new means and methods of conducting armed conflict? And if you go there, I think the next step is to say, well, then, these new means and methods of conducting this new form of armed conflict must be producing new, novel legal challenges and issues that we've never confronted. And then ultimately, you have to ask the question, if in fact that's the case, if new means and methods to conduct this new form of warfare is producing new legal challenges, is current international law or current international norms, specifically is the law of armed conflict, capable of effectively dealing with these legal issues? And that question has been asked, and it's been answered in the negative by a number of commentators and policy wonks and academics, and it's led to statements such as this. The continued effectiveness and enforceability of the law of armed conflict is highly dependent on whether the express rules remain definitive, understood, and accepted in today's complicated hybrid armed conflicts. Increasingly, the treaties and customary laws of the past century that comprise the law of armed conflict have proven completely incapable of satisfactorily resolving the myriad of legal issues arising from modern warfare. The hybridization of warfare may ultimately render the law of armed conflict completely irrelevant. Now, of course, I completely disagree with that statement. Why? Because if you look at every definition of hybrid armed conflict, and Ken touched upon some, and there are many out there, and most of them are conflicting in nature, the bottom line, when you cut through all the verbiage, is the fact that these folks have discovered that this form of warfare combines both conventional and unconventional methods and means of conducting warfare. What a revelation. Folks, this form of warfare, this combination of conventional and unconventional means and methods of waging armed conflict has been with us for decades. Now, you can put hybrid in front of it and make it sexier and produce a lot of law review articles, but the fact remains, the truth is that we have been engaged in this type of armed conflict for decades. There's a reason that the DoD Dictionary of Terms doesn't define or include hybrid warfare, because we've been there. We've done that. We've done it for decades. You know, both the Army and the Marines have captured doctrinally this type of conflict, this combination of conventional and unconventional methods, again, for decades. They refer to it as full-spectrum operations, as irregular warfare. So I want to kind of dismiss once and for all the feeling that because there's this new hybrid armed conflict out there, the law of armed conflict that it exists today cannot deal with it, because I simply don't think this is true. And again, I congratulate the organizers of this conference for the change in terminology, because there are hybrid threats, and I'm lining up. There are hybrid threats. Why are they hybrid? Because they're both conventional and unconventional in nature, and we know what those hybrid threats are, and we're going to be discussing a good number of those throughout the course of this conference. Ken touched upon this, the use of proxies. We've used proxies to wage armed conflict for decades. There's nothing new there. Cyber. Cyber poses legal challenges, but we're confronting those legal challenges. Mike Schmidt is going to be talking to us about Tallinn 2.0, and we're getting there. We're gradually realizing how to apply kinetic rules of the law of armed conflict to cyber. Propaganda, again, social media is a completely new form of propaganda. Can you sue Twitter or Facebook for hosting terrorist statements? UAVs, autonomous weapon systems, robotic weapon systems. You know, the chairman of the Joint Chief of Staff and the SecDef just said that the third offset strategy is going to be robots to counter the increasingly productive conventional weapons of China and Russia. So there's a lot to talk about there. How do you charge a robot with a violation of the law of armed conflict? The entire area of artificial intelligence. We could go on and on. Genetically coded viruses, a virus that is completely harmless to most people, all people except that one individual with a particular DNA code, and it's very deadly to that individual. So all of these are both conventional and unconventional methods and means of conducting armed conflict. But ladies and gentlemen, I'm convinced that the current law of armed conflict can be adapted to deal with all of the legal issues that have been presented by this combination of conventional and unconventional methods of warfare.
Great, sir. Thank you. Professor Blank.
Thank you. Good morning. And Charlie, thank you so much for having me again. And thanks to everyone who's put on what already is extraordinarily efficient and enjoyable conference. I want to follow up on some of what Dave said, and I want to distinguish maybe the use of a term hybrid warfare from hybrid war and suggest that what we're talking about is the former rather than some type of conflict, as you said. And I think one of the interesting challenges is how do we think about law in this regard? As we think about conflict waged with a mix of methodologies, a mix of tools, hiding military tools within other venues, in essence, by creating a false narrative. That's often, as Ken talked about, one of the key components here. So what does this mean when we think about the law? And I think it's important to think about what role law can play as we think not only about the false narrative that may be presented, but in trying to construct the narrative in response. And in particular, when we think about the law of armed conflict, we run the risk in some way in these types of scenarios of falling into the trap. If you only have a hammer, right, everything looks like a nail. So when we look at, we call a range of different techniques war, then are we going to look at each of these things through the lens only of the law of war? Or we need to maybe step back a little bit and think about other facets of international law that are relevant as we think about the use of propaganda or, sort of fomenting ethnic and religious minorities, handing out passports to your ethnic brethren in another state to then be able to make claims of defense of nationals, which we've seen. And so one of the questions is, well, if this is all taking place in the context of armed conflict, because there is actual violence going on that would meet the definition of armed conflict, whether international or non-international, depending on the situation, then we're going to be talking about LOAC, law of armed conflict. But how far does it extend? And does it have something to say about all of the different pieces of these hybrid tools? And how does it interrelate with questions about sovereignty, state responsibility, international human rights law, communications, regulation of international communications, cyber, all of these things. And so I think what we're seeing is that these types of threats, these types of tools and means and methodologies are requiring a constant thinking and rethinking in a sophisticated manner about how these areas of laws weave together and how they can be woven together as effectively as possible. And in this regard, I just want to identify a couple of, I'll call them legal challenges, although I don't think they're challenges about how to apply the law. I think they're challenges about how to use the law. One is, as we look at these multiple tools, one challenge is to identify the components of a campaign, let's call it. Let's take the word hybrid warfare out and call it a campaign, the effort by the adversary to accomplish its ends through all these different methods. And sometimes the early pieces of this are not identified as part of an integrated whole, as Ken talked about. And so one challenge is being able to recognize early on that certain actions by a state, by a non-state actor, whether it's ISIS or another, are pieces that we know, well, in the past, this turned out to be part of one of these hybrid mixed efforts. So let's be alert to the fact that this is not an isolated standoff thing, but maybe this is a piece, and maybe we want to connect it to this other piece that looks as if it's isolated or episodic. So in essence, being able to identify things that appear to be unconnected and try to link them to the whole. By the same token, there's a sort of complementary challenge of being able to then disaggregate those components once we start to see the integration. Because in order to address them effectively, both politically, strategically, but I think for our purposes, and especially in the context of the narrative, to be able to address them in the legal context and in the legal construct, we need to be able to disaggregate them in order to understand where do we want to talk in the language of LOAC, where do we want to talk in the language of state responsibility, where do we want to talk in a language of another legal regime, so that we're not falling into the trap of using a hammer and making everything look like a nail. Because while I think probably agree with most people here, I'm a big fan of the law of armed conflict, it's not right for everything, right? You can't use it for every possible situation. So I think being able to disaggregate and understand every possible legal tool that can be used in response to different situations enables the non-adversary, right? So whichever side that would be, to maximize the ability to respond, not just in action, but in legal response. The last piece, it really weaves those together, and that is being able to understand the role of international law in the narrative that's being constructed. So we heard from Ken about two primary examples, one of which, Russia in Ukraine and Crimea, actually involved an enormous amount of international law as part of the presentation of the narrative. And in a language that was presented effectively, unless you stop and actually look at, well, is the law being applied correctly? It's being discussed in what seems to be a very expert manner, throwing out the right terminology, but is it actually being applied correctly? And is it being applied to the facts correctly? So being able to actually use the legal discourse effectively to strip away the veneer of international law and get to what's underneath, I think, is very important. That challenge is greater in the alternative example of ISIS, where you're not trying to strip away an international legal argument. You're actually trying to reinforce one against an argument that's trying to discount it altogether. So it's
Dr.
a different challenge.
And we're going to look a little bit more at the actual LOAC, the LOAC principles as well, but if I can turn it to Dr. Sari, if you would.
Thank you. Good morning, everyone. Thank you very much for the invitation and the opportunity to be here. I take a slightly less skeptical approach to the concept of hybrid warfare and hybrid threats. So let me briefly try to explain why. As we heard already, there are various different understandings and definitions of hybrid warfare, hybrid threats, but ultimately they come down to two elements, the presence of two elements. First of all, the idea that the adversary is using a range of conventional, non-conventional, regular, and irregular means, and secondly, does so in a highly integrated design. I fully agree that this isn't actually anything new. We've seen this in history, we've seen it in recent history, but you can also go back into ancient times and look at Roman strategy and the various foes that they confronted, and you probably see examples of hybrid warfare and hybrid threats. However, I think this point about, and the question about is this really new, somewhat misses the point. Most proponents of the idea of hybrid warfare don't actually put it forward as a completely novel concept or as a concept that describes novel phenomena. That's not really the claim. Rather, the claim is that we are confronting novel sets of circumstances in the form of hybrid warfare. So the novelty is not so much that this has never happened before in history, it's rather about, for us, this is a new set of circumstances. Why? Well, first of all, we touched already on technology. The development of technology has produced new outlets for hybrid warfare, in particular through the cyber domain, through the internet. But very importantly, and Ken emphasized this this morning already, it's not just the fact that we have different forms of technology which provide an outlet, but it's also how we use technology, how we consume that technology, in particular how we are operating in the information domain. So it's not just the technology itself, but our attitudes towards technology and also our attitudes about law, the fact that we have very, very prominent discussions, debates, discourses on the international level about the legitimacy of warfare. That is a huge change compared to where we've been 100 years ago, but maybe even just 20 years ago. To my mind, however, the really, really important point to remember about hybrid warfare, which to my mind makes it something that is actually a distinct concept and a useful analytical concept, is precisely this combination of the conventional and the non-conventional. Because what does it mean? If we are confronting a hybrid threat, a hybrid adversary, by definition, that adversary is using conventional means against us, which means that our response will also require conventional means. It will require a military response. It will require the armed forces to be part of the package of measures that we use in order to confront that hybrid adversary. However, that hybrid adversary, insofar as we're looking at a state, purposefully keeps conflict below the threshold of an armed conflict, below the threshold of an armed attack. In other words, below many of these different legal thresholds that we know and that the adversary know will trigger our response directly through military means. So in other words, we are stuck in a situation where we are using the armed forces as a deterrent. However, we cannot use the armed forces for their primary purpose, namely combat, because the adversary prevents us from moving into an area, into a situation of combat. So in other words, the armed forces are essentially stuck in an area where they do non-kinetic activity. They do information operations, which is not necessarily their main strength. So this is precisely why, if this is what we're confronting in hybrid warfare, although it might not be a completely new, historically speaking, novel situation, it does pose very, very significant operational but also legal challenges. And what are these legal challenges? Well, the main legal challenge is precisely this problem about thresholds, that the adversary, we see that with Russia, is exploiting legal thresholds. It is trying to exploit legal thresholds like the concept of armed attack, like the concept of use of force, like the concept of international and non-international armed conflict, in order to prevent a unified response. In particular, in an alliance situation like NATO, it's actually relatively easy to use these concepts, which are quite ambiguous on occasion, in order to prevent a unified response. Deniability does exactly the same thing. Deniability of operations creates confusion. It undermines unity of effort, undermines, from an alliance point of view, a unified response as well. But there's also a broader challenge, I would suggest, in hybrid warfare, and that is, again, the question of legitimacy. It takes us back to the points that Ken mentioned this morning. Hybrid warfare, certainly of the form practiced by Russia, presents a challenge to the legal order itself, to international law itself. Now here, I would suggest there's actually nothing new. This is plain old violation, breaches, non-compliance of international law. It is a massive challenge that we need to confront, but actually hybrid warfare in this sense doesn't present anything that is new. However, the problem that we confront is still there. Irrespective of whether hybrid warfare as a concept is useful or not, we are still confronted with the fact that a major power, a member of the Security Council, is not complying with international law, and that does undermine the international order. So in conclusion, two main legal challenges that I would suggest arise with hybrid warfare, that challenge to the international legal order as such, and secondly, more specific challenges that we find in responding to hybrid threats.
Thank you, Ms. Siemion.
You got it just right.
Practiced.
Good morning, everyone. Thank you so much to Duke for having me, and to General Dunlap and Stephanie and all of the Duke law students for really an excellent job so far in organizing this panel. It has been the travel and the accommodations and everything this morning has been remarkably seamless. I will also offer a disclaimer that I am, here in my personal capacity. I work for Human Rights First, but the views expressed here do not necessarily reflect the views of my organization. I also could really just not talk and say ditto to much of what Professor Anderson and Professor Blank and Mr. Graham have said, and also what Professor Sari has added this morning, but I will tease it out in a slightly different way and make hopefully a couple of distinct points, I think. I would like to echo that I think the change from hybrid war to hybrid threats for the name of the conference was a significant one. So kudos to whoever thought to make that change. They are different concepts, and when you think about what each one of them means, you have then a different response, I think, to whether there's a need for new law or hybrid law. So much has been said already about hybrid threats. Of course, you're looking at what that means, a package of political pressure, economic pressure, misinformation, the use of Twitter, threats that are coming from different types of techniques. I think most everyone acknowledges that that's a problem. Most everyone acknowledges that that sort of combination is not particularly new, whether you want to go back to Roman times or just to the Princess Bride, which I will note actually was, I think, 25 years ago. So some of the students in this room probably were not born yet, which might come as some surprise to Professor Anderson. It's a little bit of a shock for me as well. But if you haven't seen it because you're only 25 years old, you should probably go back and watch it. There is a brand new photo spread actually from last week with all of the major actors where they are today, and they all look pretty fantastic considering that it was 25 years ago. So highly recommend that. So I think everyone's sort of on the same page about, hybrid threats, but not so much about what you do about that. Should our governments be prepared to address this hybrid set of threats? Absolutely. Are we doing enough to be prepared, as Professor Blank said, to be looking at the signs early on, looking at all of the different bodies of law, not just the law of armed conflict, that apply or that we can apply to try to address these threats? Maybe not. But that's not a law of armed conflict problem, or certainly not only a law of armed conflict problem. The law of armed conflict is only going to come into play, of course, if you have an armed conflict. So if you're operating below the threshold, has been stated earlier, then you may not have an armed conflict. The law of armed conflict doesn't apply. And also, you may not have a right to engage in the use of force if it is below that threshold. And has been pointed out, adversaries can exploit that threshold. That doesn't mean that there aren't ways to respond. Do we need to look at areas of law, like Professor Blank said, like state responsibility or the jus ad bellum, to see if there are challenges that need to be addressed if adversaries are exploiting those thresholds? Sure. Again, it's not a law of armed conflict problem, though, by itself, certainly. So those are threats. But then once you do cross that threshold into hybrid war, if you look at the literature on hybrid war, almost every single article that you will look at will be talking about something different. They don't only have just a different definition of it, but they're actually talking about completely different things altogether. So you can pick up one article and they're talking about a hybrid of international armed conflict and non-international armed conflict, where you have state actors and non-state actors, or where you have state actors who are using non-state actors as proxy forces. You will see articles that are talking about a hybrid between conventional forces or non-conventional forces. You will see articles that talk about, well, you've got a non-state actor, but now they have access to weapons that we typically have associated with states. And does that pose challenges for the law of armed conflict, where we're used to a non-state actor, they have some guns or some IEDs, but now they have tanks? Does that mean that the law that we normally would apply in an armed conflict with non-state actors, does that place some stresses on how we apply that law? I think that's something we can talk about later on when we get into targeting and LOAC issues later on in the panel. But I do want to note that there is another sort of strand out there that I think is less what this conference is about, but that is out there and is particularly important for this question of hybrid law. Because if you're talking about hybrid law, then you're also talking about a hybrid of something, of what two bodies of law are you putting together as a hybrid, and which is where I think you run into some of these problems that Mr. Graham and others have warned us about. So other folks are talking about a hybrid between law enforcement and war, actually. And that is where we really run into a lot of trouble. Yes, if you have a hybrid threat or you have an adversary that is using not just conventional warfare to defeat you, but they are posting things on Twitter, then you have to use law enforcement means to address that. But that is different from a situation where you have something that's a law enforcement problem, or you have something where the law of armed conflict actually applies. And some people they say, well, it's too hard to actually distinguish between the two. We should accept that actually we're in this constant state of war against terrorist groups all over the world. It's not going to end. And so we should stop thinking that there is this sort of, there's a time of war and there's a time of peace, and instead just recognize that it's all one mixed up mess. And so we should do away with the law of armed conflict, do away with the law enforcement paradigm, and come up with a new set of rules to address this new world that we live in. And not only do I think that's unnecessary, but I think that's very dangerous, both for the principles of law of armed conflict and also for human rights principles that normally are applicable under a law enforcement paradigm. The rules of war are designed to regulate the use of very advanced weapons, tanks, bombs. They are not designed to be governing the world that most of us would want to live on a day-to-day basis, which is what the law enforcement paradigm is designed to address. And if you want to try to combine those two, what you're going to do primarily from a human rights perspective is you're going to need to water down human rights protection significantly if you're talking about trying to deal with someone who's operating a tank all under the same legal framework. So I would caution against that particular strand. And I'll leave it there.
Thank you. So we will turn to student questions in a little bit, but I do want to pose a few follow-up questions. Each of you have mentioned, in one way or another, threshold. And I'd like to ask if you could explain to the audience a little bit and also offer your thoughts on where that threshold should be, what UN 51 has to say about it, but also frame your response a little bit and whether or not we really want to better define, from a U.S. perspective, from a Western Alliance perspective, define what that threshold should be. So should we say that this is the threshold for a cyber attack such that it implicates NATO Article 5, or are we better off having the flexibility? So what are the thresholds as you see them now, and do we really want to define them better? And if it's all right, we'll start with you too, sir. Or Professor Graham, we'll go there.
Well, in terms of cyber, as I said, I think that we're making progress with respect to the way in which you apply the law of armed conflict and kinetic operations to cyber operations. There, as everybody in the audience probably understands, a lot of issues associated with that. What constitutes an armed attack in the cyber world? What constitutes a proportionate response? What constitutes acceptable collateral damage? If you hack back and it goes through the Stanford Library and the Louvre in Paris and you take their systems out, is that proportionate in nature? So there are a lot of issues associated with cyber, but I think we're working through those. I think with respect to the threshold question, one of the things that we haven't talked about too much, it's been mentioned, but I think key to this entire area is what we view the non-state armed group as being. What is a non-state armed group? What is its status? How do you define it? Does a non-state armed group have responsibilities under the law of armed conflict? Does it have liabilities under the law of armed conflict? Is a non-state armed group terrorist? Is a non-state armed group a legitimate insurgency? Is a non-state armed group a collection of individuals attempting to become a legitimate insurgency per protocol additional to the 49 Geneva Conventions? I think we need to take a longer look at non-state armed groups in terms of threshold, because until we get a handle on what exactly we can do and not do with respect to non-state armed groups, I think it muddles the law of armed conflict to a great extent. So in terms of threshold, I don't think that we can look at Article 51 per se, because what is an armed attack in the international community today? I think the United States hasn't done us any favors, and here my disclaimer is going to come into effect. I don't think the United States has done us any favors by expanding the right to use force in the international community against non-state actors, against al-Qaeda and its associated forces. If it contends that it's in an ongoing global armed conflict, yet a non-international armed conflict against al-Qaeda, and therefore it can hit its individuals anywhere in the world, that's an expansion of threshold as far as I'm concerned. If, in fact, the United States takes the position that it also has the right to engage individuals through the use of UAVs, perhaps, because they pose an imminent threat to the United States, and yet it won't define what an imminent threat is, or it has criteria, but those criteria are classified and can't be shared. It has a decision-making process, but that decision-making process is classified and can't be shared. An imminent threat threshold is far beyond the old Caroline definition of a threat that's instantaneous, overwhelming, leaving no choice of means or moment of deliberation. That's a real expansion of even the customary right of anticipatory self-defense. So I think that there are a lot of issues out there with respect to thresholds, both with respect to non-state armed groups and with respect to the way in which the United States has said that it can respond to what it conceives as threats.
Professor Blank, you've written on this too in the context of Syria, more at an operational level, but maybe we've become too technical and where the threshold should be in terms of declaring something an international armed conflict. Could you speak to that a little, please?
Sure. I do want to, if I can, build on one piece of what Dave was talking about with regard to thresholds. I didn't forget your name. And I think it is critically important to think about the who, right? Whether it's a non-state actor, whether it's a state adversary. But I think when we think about thresholds, when we think about the types of response that's authorized under different bodies of law, we can't think about the adversary as a unitary actor, as a totally aggregated actor. When we're talking about these different types of methodologies that are mixed together, some of the actors will be positioned in a way that we can respond under a law of armed conflict paradigm, under some type of use of force paradigm. Some are not. We've seen over the last 15 years the challenge of trying to lump lots of different types of actors operating at different levels within a threat paradigm into one group. And that goes to the challenge of trying not to let law of war and law enforcement blend together too much. And so it's important to be able to differentiate between the non-state armed group and its members and those who are fighting in a, whether it's a non-international armed conflict scenario, and someone who is also a non-state actor, but is not connected to that group in such a way that they are a member or participating in the conflict such that they are subjected to loss of immunity from attack or other consequences. And so we have to understand that threshold is not going to be across the board. And we have to be able to separate out the who. I feel like I'm in a Dr. Seuss book. Separate the who's. But I think, if nothing else, that could be a motto, maybe. So I guess that goes with what I often present to my class, and they're too young to remember these books, but I think many of you here would. The Richard Scarry books, right? Who are all the actors in the neighborhood? And you lift the little flaps. They all look at me blankly because they haven't seen these books. But I think there should be Richard Scarry, who are all the actors on the battlefield, and then we could have a new version of it. But when it comes to thresholds and technicality, I think, as I was thinking about your questions that you sent us, I think we want to continually tether the law, and in this case, we're talking about the law of armed conflict when we talk about thresholds for either IAC or NIAC. We need to tether the law to the principles that underlie the law. And so I wouldn't, say always we're being too technical or we're not being careful enough in applying the law, but it needs to remain tethered to the purposes. And if you start to separate that out, and if becoming overly formalistic in applying the law attenuates that tether, that's when we start to have a problem. And as long as we remember that we have this body of law in order to, protect people, to regulate the conduct of hostilities, minimize suffering of civilians, go on and on as to the purposes of the law, then we can think about how we are applying specific rules, specific thresholds to make sure that we are staying true to that, and to not be overly flexible, but just simply be able to say, as you mentioned in the case of Syria, let's talk about whether this is an armed conflict. Okay, maybe we can't identify the exact organization of the groups that are fighting against Assad if we go back 3 or 4 years. Now I'm not sure anybody could diagram it, but let's just look at this practically. This looks like an armed conflict, right? It quacks like a duck. It is a duck. So I think there we want to remain true to the principles.
Thank you. So running with the idea of keeping this very simple and stripping out some of the technicalities, ultimately the question about thresholds comes down to this. It boils down to this very, very simple issue, namely, can the armed forces which are facing a kinetic threat, and remember, if we are talking about a hybrid threat, a hybrid warfare situation, we talk about the armed forces being involved in it because we are facing a conventional adversary. So can the armed forces use kinetic action? Can they use lethal force? Can they kill people, blow stuff up? That is ultimately what the question of thresholds boils down to. If the answer is we are below the threshold, then the armed forces cannot engage in lethal action. They cannot blow things up. They are stuck with either law enforcement paradigm or human rights law or basic consent of the local host state, et cetera, et cetera. Whereas if you are above the threshold, then we are in the context of an armed conflict, whether it be international or non-international, or in the area of use of force and self-defense and all the rest of it. That is ultimately the question. Now, what are the consequences? What are the legal consequences of this? First of all, if the adversary plays on that threshold and keeps whatever activities it is undertaking below that threshold in order not to trigger a kinetic conventional response from us, that means two things. Number one, where the thresholds lie, what they mean, what their content is, becomes very, very interesting. It becomes interesting not just for us lawyers, but also for the military. All of this sudden, attribution becomes one of your mission objectives, because if we can pin it on the other guy, then perhaps we're in the business of kinetic activity. So actually it creates quite a few incentives to look at the thresholds and to perhaps even shift the threshold or start thinking about whether they lie in the right place or not. I'm not expressing a view on whether they should come lower or higher, but there is a danger of incentives about shifting these thresholds. The other major legal challenge, and I touched on that already, is that if we are definitely below the threshold of an armed conflict, international, non-international, or use of force, then we, as the armed forces, are stuck in a law enforcement paradigm. And that's actually, the question is not so much, are we doing law enforcement? The question is, it's the military guys doing stuff on Twitter. Question, what's the law? Into which legal framework does that actually fall? If you're operating with the consent of a local state, because you're deployed again in an alliance context, what does local law say about this? What does human rights law say? What does your own, or what does the national law of the different coalition partners in an operation say about investigating or collecting information about people on Twitter? That's where we see the legal issues. And they're not law of armed conflict issues. And they are gray, they are ambiguous, they're really difficult.
Ms. Siemion, that's part of your concern from your earlier comments.
Yeah, I mean, I think that's right. I think part of the conundrum is that you have law of armed conflict lawyers, and they don't know what law to apply because it's not the law of armed conflict. So you have to pick up the phone and call some of your friends who work in other areas of the law, those who work in cyber, not cyber warfare, but those who work on state responsibility, accountability, et cetera. So there's a whole host of both international and domestic bodies of law that apply. And so when you talk about sort of a hybrid threat problem, part of it is that maybe we need to get it together a little bit more and have the different areas of the law and different experts integrated so that they can respond more effectively when it is below that threshold. But I did want to say also, more broadly on the threshold question, that we're talking about two different sets of thresholds, and both of which are there for a reason. So for those who aren't super in the weeds on the use ad bellum and law of armed conflict, there's a threshold about when you can use force in the territory of another state that falls under the use ad bellum. And that's when you're talking about, after 2 world wars, we decided that maybe we don't want to go through that again. So we set a pretty high bar. You need to go to the UN Security Council in order to use force in another state. Or if you're being attacked or about to be attacked, then you, of course, can defend yourself. So there's that threshold. And you cannot use force in the territory of another state if that threshold has not been satisfied. Now, if a state is sort of deliberately acting below that threshold, then that's when, again, the laws of state responsibility kick in, but not your right to use force that doesn't kick in. We can talk about whether the armed attack threshold is too high or not, but I would again suggest that we set that threshold for a reason after living through 2 world wars. But then there's a separate threshold that's very important about when the law of armed conflict itself kicks in. So yes, you may be able to go into the territory of another state and use self-defense. That doesn't mean that it's an armed conflict. You may be able to go into another state and address a threat that is emanating from that state. But if it's not the state itself that is attacking you, it may not be the law of armed conflict. If a state uses force against another state, the law of armed conflict is automatically triggered, right? There's a very low threshold for state-to-state armed conflict. But if it's a non-state actor, then you need to have an actual organized armed party that this non-state actor has formed, and you need to reach a level of violence that takes it beyond a law enforcement problem where they are using weapons of war, for instance, and there's this level of violence that Professor Blank has talked about. Like, does this look like a war? Do you have 2 parties who are shooting at one another? And that threshold is extremely important with respect to non-state actors, again, because everything that falls below that, it's a very different set of rules that applies to that situation.
So let me, before handing it over to the students to ask some questions, let me ask in the context of a real-world example that gets a lot of attention in military circles. And here I, too, will say that I'm just speaking for myself, not NDU, the Air Force, or anybody else for that matter. But one of the principal lessons that we teach at the War College is the difference between the nature of war and the character of war. And one of the main pieces from that is the nature of war is enduring. It doesn't change. It's always going to be violent. People are going to die, and it's going to have a lot of passion involved with it. But the character of war changes. And the question is, as the character of war changes, is the law of armed conflict, and I'm looking at that specifically, keeping up? So the example is, you think about the Israeli experience with Hamas in our example. During World War II, of course, which you mentioned, the fight between 2 armies, they would fight each other, and you would win the war by destroying the enemy's army, and victory would attain from there. The conventional wisdom, at least now in the academic circle I'm in, is that the character of war has changed such that now you're fighting to destroy the enemy's legitimacy. And you do that however you can. So when the Israelis roll into Gaza and they do hit somebody because of the changes in social media, that Ken had talked about before, the character of war itself has now significantly changed. Looking at the law of armed conflict, which largely emerges from the character of war that existed from the 19th century until the end of World War II, or you could say the dissolution of the former Yugoslavia, compared with where we are now, do you believe the law of armed conflict is up to date, is accurate, or what changes do you think need to be made, especially as you talk to the young judge advocates and the aspiring judge advocates that will have to advise on this here as soon as tomorrow, depending on where they are?
Okay.
I know I didn't send you that question ahead of time, so that's on me.
One of the points I was attempting to make in my initial remarks was this contention that we have a hybrid form of armed conflict out there now with these new legal challenges, and therefore the current law of armed conflict is not sufficient. We need to revise, we need to completely modify the law of armed conflict. Nothing is tougher in this world today than attempting to engage in asymmetric urban armed conflict. And that's what the IDF, the Israeli Defense Force, has been confronted with for the last 2 decades at least. They've had tremendous targeting decisions to make, as well as other decisions revolving around the law of armed conflict. And I think, and here again, I am speaking for myself, but I've had a number of occasions to travel there and deal with their military. I think the Israelis have gone to uncommon lengths to attempt to prevent collateral damage and to target as targeting should be under the law of armed conflict. The point that I always make, though, is that we should not allow non-state armed groups to dictate revisions in the established law of armed conflict. We do not lower the law of armed conflict principles and standards to those that non-state actors would like for us to have. What we do is to enforce, and enforce with great gusto, the current law of armed conflict principles and make sure that we enforce them and that they remain legitimate. So, as a brief answer to your question, I think that we can adapt the law of armed conflict as it currently exists to asymmetric urban armed conflict scenarios. And with that goes the question of whether these non-state armed groups that would have us lower these standards, are they held to responsible actions? Are they liable for their actions? What standards must they adhere to? I think they get off fairly easily on a lot of the investigative bodies that conduct investigations after these incursions. A Goldstone report is a prime example of that. So no, I think that we can adapt the law of armed conflict, the law of armed conflict principles, the basic principles of military necessity and distinction and discrimination and proportionality and collateral damage. Those can be adapted to that type of warfare. And I think that Western militaries are confronted with those issues, and we're dealing with those issues, and we've done a pretty good job of doing that. So sorry for the long answer.
That's great. Ms. Blunt, please.
Yes. I would start by maybe quibbling with your initial premise that legitimacy is a new target, I guess, in war, because when you start by saying historically we fought wars to destroy the enemy, we were actually, it's always been about destroying the enemy's legitimacy. It's just that legitimacy was defined by the ability to control an area, to exert governance power, and so on. And now when we think about how legitimacy is defined in a lot of current conflicts, legitimacy is not defined in the same way. And now a huge piece of legitimacy in the context of war is about international law compliance. So we saw this transition over, the last half century or more. For a long time, legitimacy was about whether you were fighting a just war. Did you go to war in a legitimate manner? Did you have a justified reason? That's transitioned again now to how are you fighting this war? Legitimacy is based on not just your actual compliance, so we keep moving down the path. It's not just actual compliance with international law, it's the perception of compliance with international law. That's the touchstone of legitimacy in today's conflicts. And this, in essence, if you are the law-compliant military, you are starting off with a massive handicap here. Because if we think about the context that this type of war is being fought in, the urban environment, non-state actors hiding in the, commingling with the civilian population, think about what the war is actually about. It's about death and destruction in an urban environment. People who have no business being hurt and having their property destroyed are, in fact, suffering exactly those harms, whether something is lawful or not. That's just the factual situation. So the delegitimizers, if I can make up a word, and those of you who know me know I do it all the time, they start out with a bit of an edge, right? The party that has the superior military capability automatically is causing more destruction, just as a factual basis. So, you start out with the edge of that factual scenario, and you weave in superior military capability and a commitment to comply with the law on one side, and a disregard for the law and for whatever harm might be caused to their own people on the other side. And you have a very combustible recipe right there. So I just want to make one quick point in this regard. We talk about legitimacy and what this means for fighting this kind of war. And I think what this comes down to is not that we need to change the basic principles of the law of armed conflict. I would go in the opposite direction and say they're ever more important. When we could have a long discussion. Which principle would somebody want to change? Do you want to change the principle that says you have to distinguish between people who are fighting and people who are not, and only attack those who are fighting? That can't possibly be the right answer in an urban environment. It's about communication and about how we communicate about the law. That is really one of the biggest challenges, because again, the touchstone here is perception of law compliance. And so in a couple of areas, we can see this challenge. Whether you're talking about proportionality and the incidental harm to civilians, whether you're talking about what actually can be attacked, what is a military objective. These are areas where the law-compliant military needs to think really hard about how do we communicate effectively about these concepts within the boundaries of what information is reasonable to share, and how quickly can we communicate about this effectively. So the minute claims of a law of war violation are out there, it's impossible to take them back. It's like trying to put the genie back in the bottle, right? We all know that's not possible. And as states lose control over the gathering and dissemination of information, this gets harder and harder. So I think we need to have a long, hard look at how do we talk about terms like military advantage, because the discourse about proportionality and collateral damage and incidental harm is entirely about civilian casualties right now. And I don't say this to suggest that it shouldn't be about civilian casualties. That's what proportionality is designed to do. It's designed to minimize those. So the conversation should be about civilian casualties. But there's another piece of the puzzle, which is the military advantage. And if you only talk about proportionality in the lens of civilian casualties, you're not really talking about it, because the whole point is it's looking at two components of the attack. And so we have to be able to talk more effectively about why something is a target. What is the military advantage gained? The same thing goes to the idea of what is a military objective. When we think in the Israeli context, what kinds of things can be targeted, it's uncomfortable to talk about targeting a school, a UN facility because Hamas is firing from the compound, from the roof, something like that. But a more effective discussion of what makes something a lawful military objective, I think would go a long way to better communication about these issues. I don't know if that goes far enough in the legitimacy area to be, to make a big difference, but I think it certainly could help.
So Professor Sari, if you could follow up on that, but also build a little bit. I mean, what we do see, though, is institutions, the ICC, the Goldstone report from 5 years ago, the new UN Human Rights Commission report on the last Gaza war. They're not looking at the legitimacy of the targeting so much as they're looking at the narrative, which shows that civilians are dying. So if you could comment on that, too. I mean, how do you manage that?
Can I disagree first a little bit? Because I think the questions that you mentioned, they're absolutely fundamental. They are really important questions, but they're not new, and I don't think they're really distinct to what we confront in relation to hybrid threats. The issue, I think, is about legitimacy. You're absolutely right to say that legitimacy has always been part of wars. I mean, they haven't just been fought over territory. Legitimacy is part and parcel of it. However, the fact remains, as you mentioned, that low-value conflict is very much steeped in a kinetic mindset. If you look at the rules on targeting, they are about targeting in attack. It's precautions in attack. What is attack? Violence. It's, again, killing people, blowing stuff up. So the rules that we have in LOAC are very, very, very much tied to kinetic. Now, there are, of course, some other rules as well. For example, offering advanced warning to the civilian population. You could conceivably say that's a more non-kinetic activity. Detention, we have very elaborate rules on detention. Of course, detention is physical, kinetic in that sort of sense, but you're not killing people. So it's a mix. It's not just purely about death and destruction. But nonetheless, on the whole, there are many, many rules which we are missing. For example, rules on information sharing, rules on intelligence gathering. Low-value conflict has nothing, or very, very little to say about these things. But the fact remains, we do it. As a military, we do it. So, if we're not in an armed conflict, then the answer is relatively simple. Low-value conflict doesn't tell us anything about this. So it will depend, the legality of these activities will depend on domestic law, they will depend on international human rights law, etc. The really interesting set of questions, I think, which we need to add to the ones that you mentioned, is that if we are, in fact, in an armed conflict, whether it be international or non-international armed conflict, and we continue to engage in the non-kinetic type of activities, intelligence gathering, twittering, undermining the adversary's narrative legitimacy through social media, if that's what we do, and the low-value conflict has very little or nothing to say on it, then there's a gap, isn't there? The question is that gap intentional? In other words, are states free to engage in these activities, unregulated? Or is it a gap, and this is very much something that's alive in Europe, is it a gap which ought to be filled by human rights law? And if the answer is yes, and law of armed conflict doesn't actually put anything into that gap, we have a problem. So it's not just the questions about military objective and military advantage, what do these things actually mean, but also these gaps that we seem to increasingly come across. I mean, targeting in a real life sense. Targeting is the whole process, the full spectrum. It's the kinetic, it's the non-kinetic, it's key leader engagement, it's talking to people. That's not what law of armed conflict really understands when it talks about targeting. And I think there we will see, in coming years, we will see increasingly human rights law arguments and human rights discourse potentially looking at that and looking at it as a gap. And that could be quite dangerous.
Siemion?
So you might be unsurprised to find out that I would disagree with that framing. I think it's right to say that the law of armed conflict primarily governs kinetic activity. And I think that that's what it's supposed to do and what it should continue to do. I don't think it means that there is a gap necessarily for the law of armed conflict to not go outside of that space, nor do I think it means that you have to look to human rights law the way that many of us think of it to fill that gap. So you have all the rest of the law that we apply domestically and internationally. Now, you could, that's not sort of human rights law, which, yes, that falls under a sort of the human rights paradigm or a law enforcement paradigm, but it's human rights law is actually a specific, there's a set of treaties, et cetera, that we would think of as human rights law, which is a little bit different from the paradigm that is applicable outside of armed conflict, which is basically everything else. So we have a panel later on today and tomorrow on surveillance. We have a panel on cyber, and both of those areas cover a wide range of different bodies of law that govern non-kinetic activity, including information sharing domestically and internationally. Now, do we need to fill gaps in those areas? I would think probably, given all of the technological changes and globalization that we have seen. The world is a very different place today than it was 20 years ago, and those changes have to be addressed and reflected in the law. I would disagree that the law of armed conflict is the place to address those.
A point of privilege.
Sure, sir.
My European colleague has, of course, introduced the idea of this conflation of the law of armed conflict and international human rights law. And obviously, that is a point of contention. But as the U.S. lawyers in the audience understand, I think the United States has long taken the position and continues to take the position that with respect to Common Article 2 conventional international armed conflicts, there's no doubt that the law of armed conflicts is lex specialis. It excludes every other kind of law. The question becomes, in a non-international armed conflict, if we can define non-international armed conflict in the 21st century, the question then becomes, does international human rights law supplement those provisions of Common Article 3, or if it's a high enough threshold, Protocol 2 additional to the 49 Geneva Conventions? There, I think, if you're a signatory to the International Covenant on Civil and Political Rights, international human rights law may well have a role to play to fill those gaps. But I want to go on record once again as saying, if you're talking about conventional conflicts, I think that the law of armed conflict, both customary and codified, is lex specialis. It displaces any other form of law, and there's no real role for international human rights law to play in conventional Article 2 conflicts. So thanks for the opportunity.
Thank you, sir. Okay, at this point, we'll invite some questions from the audience. Is there a microphone person? Or? We have a couple of microphones. Sir.
There's been quite a bit of discussion about the concept of a threshold.
Let me just get you the mic, sir, just to make sure that also the people next door are on a sound feed.
Thank you. There's been quite a bit of discussion on the concept of a threshold and the difficulty in establishing when has that threshold been crossed. Professor Blank introduced the concept of a campaign. I'm curious as to, does the law speak to the concept of a cumulative effect, where through a number of, I'll call it, disparate events that are disparate in time, maybe disparate in geography, disparate in targeting, disparate in vehicle of delivery, that it crosses some kind of cumulative threshold.
And we'll use CNN debate rules, so if you're actually mentioned in the question, you get to comment. So you get to go first. Dr. Blank. Professor Blank, sorry.
Yes, well, I use the word campaign in the very ordinary English way, I don't think it has any particular legal meaning. Although it's nicer to use the word campaign for something other than the current political campaign that's going on. So happy to introduce a new definition here. Does the law speak to an accumulation of activities or effects? I'm going to give you a very classic lawyer answer, and it depends. I mean, the idea when we're talking about, we've hit on threshold in a couple of different areas, and Rita framed them for us before. In the context of whether or not a given situation is an armed conflict so as to trigger the application of the law of armed conflict, it's an incredibly factual analysis. So, in the context of international armed conflict between two states, you don't need to have an accumulation of events because it's almost a one-shot threshold. It's a very low threshold. Anytime you have an engagement between the armed forces of two states and a dispute between those states, you have international armed conflict. So we wouldn't get to that question in that regard. It could come up in the context of non-international armed conflict, and that's really the U.S.'s argument with regard to a conflict with al-Qaeda. And there have been significant disagreements with whether that isn't a reasonable argument at all. I think the bulk of the contention with the U.S. argument about episodic terrorist violence being an armed conflict has to do more with which episodic things the U.S. is drawing on, right? So there's two different questions about whether that can be a threshold. Can it ever constitute an armed conflict, or are the things you're relying on sufficient to meet a threshold? So I think it also depends upon who is launching these accumulated events. You'd want to be able to show that they are the same group. Because the fact that a state is getting hit by multiple threats, multiple attacks, and they're coming from different groups, you can't then lump them together and say, we have a war on terror or a war on people attacking us. That doesn't work, right? You need to be able to define the opposing entity in a non-international armed conflict. So huge, it's totally fact-dependent, I guess. I don't know if that helped at all. But.
Further thoughts?
The answer was classical, it depends.
Yeah.
It's like most things in life.
Further thoughts on that?
There certainly have been instances when cumulative effects have been taken into consideration. Goes back again to the issue of non-state armed groups. If this particular non-state armed group happens to be a terrorist organization operating out of a third state, and let's say the United States says, look, they've hit us once, we ask you to stop them. They hit us twice. Now, there's this concept of state responsibility, and if a state is either unable or unwilling to prevent attacks emanating from another state's territory, then we're going to consider that to be, at this point, an armed attack, and we're going to take a proportionate response and wipe out the threat before it continues. So those are all cumulative effects that can build to that point after warnings to another government.
Professor Sari?
Just a very quick point. I mean, we have to be very careful about the different thresholds because there are different thresholds in law. So, for example, under the law of armed conflict, if the question is there a non-international armed conflict or not, because we're looking at the organization of the group, we're looking at the protraction of the violence, the level of violence, you will actually almost by definition look at an accumulation of events. I mean, there's hardly going to be a single event where all of these things are satisfied. So their accumulation is not really controversial. By contrast, precisely in relation to use of force, whether pinprick attacks, small attacks, then add up, and at some point tip over the threshold of an armed attack giving rise to self-defense, I think that is slightly more controversial. So we've got to be very careful and distinguish between the different types of thresholds and the different areas of law.
Siemion?
Yeah. I think I would agree, actually, with what everyone else has already said, so.
Great, okay. And if you could introduce yourself too, suspect most of us know you already, sir, but if you could introduce yourself.
So I'm Mike Schmidt from the United States Naval War College and also from the University of Exeter in the United Kingdom. So I think this is much to do about nothing. I agree with Dave 112%. There's very little that's new here in this hybrid warfare. And I think, I think Dave and I would probably agree we've been through this navel gazing over and over and over in the past decades. Because remember, not too long ago, we were holding conferences on asymmetrical warfare, and before that it was transnational terrorism. And at the end of the day, we usually come back to the same answer, and the answer is the law works pretty well with a little bit of interpretation for new circumstances. I mean, the cyber warfare, Oral, with respect to examples that you cite, intelligence gathering, sharing, I don't see any issues with regard to that because Rita's right. To the extent that LOAC doesn't deal with this, it will be dealt with by other bodies of law, such as human rights. Now, we may argue about whether human rights apply because of lex specialis or not, but I think we always look to the other bodies of law. And with regard to the problem of thresholds, what do we do if people are operating below the thresholds? We do what international law has been telling us to do for a century. We look to the law of state responsibility. We look to the law of sovereignty. If we want to respond, we take measures in retortion. If we want to respond, we take measures that involve countermeasures. If we want to respond, we respond pursuant to the plea of necessity. There are lots and lots of things you can do when you're below the threshold. It is not a problematic scenario. But I do want to raise one issue that the group hasn't mentioned, and Laurie has written on this a great piece, and it has to do with borderless conflict, because I think this may be new. And the reason it's new is if you take the approach of the ICRC, and I know Rob Ramey's here, so maybe he wants to respond. If you take the approach of the ICRC with regard to the extension of the law of armed conflict geographically, it only extends during a non-international armed conflict, which is what we're mostly involved with at terrorist groups, through the country involved and into the bordering area. And so what this means is that if you're engaged with a particular non-state actor, a particular organized armed group, the body of law that applies depends on geography. If you're fighting them in your country, you look to LOAC. If you're fighting them as they spill over, you're fighting in accordance with LOAC. But as soon as they move beyond that, you're fighting with this very same group with international human rights law and all the other peacetime bodies of law. So I don't buy this approach. In my view, LOAC depends on who the parties are. It's an IAC, it's state on state. It's a non-international, it's state on organized armed group or organized armed group on organized armed group. But I'm very nervous that this idea of a geographical limit to warfare will de facto drive us into hybrid warfare, where the United States is fighting a particular group, and as soon as my jet passes a particular geopolitical border, now the rules switch. Now I can't engage in status-based targeting. Now I have to engage, for example, pursuant to the rules of self-defense. So in particular, Laurie, but also the other members, I wonder if you see this as a problem that might very well create hybrid warfare.
And let me just mention, so ICRC, International Committee for the Red Cross. Rob, where are you? You're in the back, so if you have questions about the ICRC. Do not give that man a microphone. Please.
Thanks, Mike. I do think this is a really interesting issue, and I want to add a piece to what you raised that I think shows some of the interesting contortions that this question of geography and bordered or borderless conflict can raise. And let's look at the way the U.S. has viewed territory in the context of what it views as a conflict with al-Qaeda and associated forces. And by that I mean, how has the U.S. viewed U.S. territory versus territories where it's actually engaging in kinetic activity? If you think in a more conventional construct, when a state is fighting another state, the territory of both states is belligerent territory. It's part of the conflict, the theater of operations, whatever term you want to use. And so during World War II, U.S. courts, when cases came before courts about whether particular parts of the U.S. were considered part of the area of operations of the conflict, they affirmed the Port of New York or something else falls within belligerent territory. Interestingly, in this conflict, that the U.S. has pushed the concept of conflict with a transnational terrorist group on the world, in essence. I mean, the U.S. is the initiator of this idea. The U.S. very firmly views U.S. territory. So the territory of the only belligerent party with a defined territory as not part of the territory of the conflict. I think the government views it this way based on how the government responds to actors that it encounters on U.S. territory. The courts have viewed it this way. They talk about far from the theater of hostilities, off the active battlefield. So I just throw that out there. It adds another piece, because do we take a state's view of the geography into account? And it seems a little odd that the U.S. views absolutely anywhere in the world that it wants to launch a strike as, in essence, belligerent territory, but not its own territory. So I add that as an interesting, I don't know what the answer is to that question, but I add that as an interesting piece. I tend to agree with you on the question of borders, and I think if we look at the practical consequences of one construct versus another, if you have a rule that says when you cross this border, you're no longer in a conflict area, where is this non-state group going to go, right? This is not a trick question. It's going to go into that area. And then do you restart the process of how we identify a non-international armed conflict? Do you restart from this question of, do you have protracted armed violence? What is the organization of the parties? It's like Groundhog Day. You're rewinding the tape. All right, let's start again. Can we respond? Now we can't handle the situation. That doesn't make a lot of sense. However, I think if we take that to the end point as far as you can push it and say anywhere is part of the conflict area, we have another practical consequence that's really problematic, that now the whole world is a battlefield, to use an old-fashioned term in sort of a new construct. And when we think about the role of law as expectation, as how we think about what is likely to happen, right? That is a huge purpose of law. What do you anticipate is going to happen when you live certainly in a society governed by the rule of law? The idea that anybody anywhere is now living in what could at any moment be a combat zone simply because bad guy number 1 or number 5 or whoever it is happened to pass through there, that's problematic. I don't know exactly where the answer lies, but I don't think we can simply disregard one as impractical without recognizing the impracticality of the opposite extreme.
Why is it? Give me an example. Everyone always says this, but no one can provide examples of why it's problematic.
Why it's problematic? Well, I would go to the practical scenarios. And does a state, the U.S. in this situation, consider that Stockholm is part of, I'm going to say, the zone of combat, which doesn't have any particular legal meaning, right? But a place where you can use lethal force as a first resort because whoever it is there. ISIS somebody, an Al-Qaeda somebody. No, I don't think the U.S. in any way views that it could use lethal force as a first resort. You think so in Stockholm? And cause collateral damage?
That's different.
Dr. Siri
Right?
chomping at the bit.
And so
Let me let Dr. Siri
with a
respond
simple,
because he's.
but no. So how many?
Have you lost control here?
Almost.
Well, no. I would ask to the
I'm
audience,
about to call in
how
an
many
airstrike.
people? If an entire, right, is it one person going into another country that makes that entire country now part of the conflict area?
No.
That seems problematic.
All right, Dr. Siri, so from the across the pond
Yeah,
perspective.
just quickly. I mean, the point from the way I would view it is the point is that person in Stockholm they are a legitimate target, which means that they do not enjoy immunity from attack. That's it. But that doesn't mean that you can go further and that you can actually cause collateral damage, etc. Because there's a whole set of other rules as well, which apply at the same time, human rights, use of force, etc., which prevents you legally, never mind the policy issues, it prevents you legally from actually engaging that person. All that we're saying is that that particular person, at that point in time, does not enjoy immunity from attack.
Okay, and your colleague to your left looks skeptical as well.
So I actually had on my list that I didn't mention that there are 3 areas that, at least with respect to armed conflicts with non-state actors or transnational armed conflicts, that pose challenges to the law of armed conflict, and one being targeting. There's not currently agreement about who can be targeted, and there's direct participation in hostilities, continuous combat function, or just membership in the group, and currently there's no agreement on that. Geography is another one, and detention for the duration of hostilities is another potential problem area if hostilities are going to continue for years and years to come with these armed groups. Do we want to be holding people for decades and decades? So I do think those 3 areas are problems. So geography, I would agree with Professor Blank that we're sort of looking at 2 somewhat dissatisfactory options. So, I can understand that we want the law of armed conflict to follow the fighters, and why is that person no longer a target because they've crossed the border? I understand that concern. But there also is this concern that do we want to be just walking up to someone in a cafe in Paris or Stockholm, or take your example, and shooting them? Or, here at Duke, you've got a member of ISIS sitting here in this room. Do we want states to be able to, no collateral damage, just point blank shoot that individual person? And, so I think the United States would say, we have the authority to do that, but of course we would not do that, and they will invoke the unable or unwilling test to say, well, if France can take care of it, they can arrest the person. I don't find that comforting, only because that is not a legal obligation that the state is taking on. They're saying we wouldn't do it as a policy matter or as a practical matter, but as a legal matter, could we? And I find that unsettling. If you turn it back to the presidential election, it's foreseeable that we could have a commander-in-chief who would have no qualms about using lethal force in those situations even with a legally binding constraint, for that matter. So,
I'm sorry I brought up the election. Let me do 2 things. And the thing is, I think, Professor, you're later in the agenda anyway, correct? Right. Yeah, but you're going to get the last word, which is great no matter what we do. So, Professor Graham, and then I'd like to open it up probably have time for 1 or 2 more as well. But thanks for introducing that topic.
I'd take a much more simple approach toward this, Mike. What type of conflict is the United States engaged in the Middle East? In Afghanistan, is it a non-international armed conflict against the Taliban? In Iraq, is it a non-international armed conflict? Obviously, it's a non-international armed conflict. Laurie and everybody was talking about is the fact that the United States has turned the concept of the non-conflict against the United States. And so what law does it apply? That's your hybrid armed conflict, folks, right there. And it's produced hybrid law, because rather than applying the regime that relates to terrorism or Common Article 3 or Protocol 2, the United States has chosen to apply to these unlawful combatants some of the aspects of terrorism law, some of the provisions of Common Article 3, but very importantly, selected provisions of the law of armed conflict that applies to Common Article 2 international armed conflicts. That's an amalgam of 3 legal regimes. That's hybrid law. So that hybrid conflict equal hybrid law, and nobody quite understands how you apply that. And I think the universal jury is still out as to whether that rather blatant act of unilateralism on the part of the United States is going to stand the test of time. So,
Professor Blank. Let me get Professor Blank, and then, yes, we'll open it up to the ICRC. Yeah, we'll turn it over to you second, Rob, for your question. So go ahead.
Yeah,
and then
I want to entertain you by coming back to your point briefly. And I think if we follow step by step, we can see where at some point we might start to feel uncomfortable with the result of following one legal conclusion. And sometimes I think it's useful when you get to that point of discomfort to stop and think, what is causing this discomfort and what is the solution to it? Is it law or is it policy? So if we step out of the al-Qaeda environment and look at ISIS, we're now striking ISIS in Libya. That's not the geography of Iraq and Syria where this non-international armed conflict is going on. We don't see any discussion about, is this expanding the geography of the conflict? I mean, there's some factual discussion in the news, but doesn't seem to be a lot of legal discomfort with that. And because they've taken the conflict to Libya and we're following them there. And they have entire units there and they're engaged in fighting there. And so in order to effectively carry out our operations, we need to stop what they're doing there. That's different factually from one guy who goes far away. It's different factually. Is it different legally? That's a separate question.
That's the point.
Right. No.
For lawyers, it's not different legally. Fact will
Well,
be policy, but as a matter of law, there's no legal difference. You're ignoring bodies of law like the jus ad bellum. You're ignoring sovereignty, the law.
Hold
of
on. I wasn't
self-defense,
finished.
et
Hold
cetera,
on. So
first of all, we need a bigger panel, okay? And I do want to do this if I can. If you could take like 1 minute to fire the last round over there. Okay, watch the collateral damage because the people next to him have nothing to do with this. Okay, and then I do want to open it up to a question or two from the students. And Rob, I know you're on the agenda too, right? Okay, so you still get the last word. So, hey man, help me out down here. We're just
right.
okay.
No, I think you brought in the jus ad bellum, and that's where I was going, which is what other law can we use to help answer this question? And so some would argue that if you're in a non-international armed conflict, that's all the jus ad bellum you need to cross a border into another state. Some would argue that. Some would say it tells you nothing about your ability to cross a border, and you need an entirely separate jus ad bellum justification, which is your, in self-defense or when any of the others consent. So in the context of the ISIS operating in Libya, either we view that as we don't need any other justification other than the fact that we're engaged in a non-international armed conflict, or the U.S. is saying we're acting in self-defense against a threat emanating from Libya, from ISIS in Libya. I don't know which one it is, and the chairman of the Joint Chiefs hasn't called me to tell me which way they view it, but it's one of those two. If you have the single guy who goes to Stockholm, it's a different, in terms of how, you're going to look at jus ad bellum the same way, right? The rule is still the same, but how you actually apply it to the situation, it's a harder argument to make, right? And that then bears on how we think about whether or not this is part of the conflict.
So Laurie,
That's
let me do
answer.
this. Okay, so
Can
I know,
you use force?
Laurie, hold on.
Is it part of the
Okay,
conflict?
note to self, if you're ever up here, go to first names right away, forget the professor stuff, try and get on the same plane. I do want to do this. We've got 5 minutes. We've got a lot of students here. No questions about Stockholm because you see what it does to the panel. But students, if there's any students or attendees or, let's say, officers in the grade of 04 or below who would like to pose a question to the panel, let me invite that now. Okay, so we've got one up here. So. And please introduce yourself if you would.
Yeah, I'm Cyrus Hogan, uninformed bystander. I'm curious how the panel might look at the principles behind LOAC, human rights law, civil and criminal laws that can be used to deal with these issues, how they might differ and how the actions of the combatants might affect these principles.
Okay. Do you want to maybe come up with an example from that you're familiar with yourself or something that you've seen or have read about?
I'm just ignorant of the principles. It would seem to me that all the principles are the same. There's been some general discussion about this, maybe this is a totally off-base question. Maybe it's too simplistic, And sometimes you get so far removed from that when you're discussing these issues. Maybe nobody has any opinion on this.
No, it's a great foundational question.
Yeah, because I have no foundation.
No. I thought I did. Okay, so, all right, Professor Graham,
Professor?
thank you for the question.
Well, there is a body of international criminal law, and in the context of the law of armed conflict, you can charge individuals criminally for violations of the law of armed conflict. In the United States, we charge them under specific provisions of the Uniform Code of Military Justice. But if you want to take it out of conflict and just take it into the arena of criminal law and whether you can charge somebody criminally, there is a body of international criminal law under which you can do that. I don't know if that's what your question gets to or not, but that nevertheless is my response. So,
Go ahead. Laurie, if you would.
Yeah, let me offer what maybe I think you're getting at is why does it matter that we're talking about these different bodies of law and arguing about which one applies when, or maybe not arguing, but discussing which one applies when. And I will put it in very stark terms, which is that if you're talking about applying the law of armed conflict, which applies when you're in a situation of armed conflict, and we've talked a little bit about what triggers that, it's very different from applying what I'm going to call ordinary law, which is the law that applies like our law enforcement paradigm. Why is it different? It's different because under the law of armed conflict, we identify an enemy. Our adversary in the conflict is the enemy. And the law of armed conflict allows one party to use lethal force as a first resort against anybody in the enemy forces. We don't have lethal force as a first resort in our law enforcement paradigm. That would be hugely problematic, right? It's a last resort in law enforcement. So that's one big difference. So it's incredibly consequential whether you're in an armed conflict or not when we think about how people are treated in terms of how they are at risk of the use of force. Another area that's very different is detention. In armed conflict, under the law of armed conflict, you can detain members of the enemy forces without charge until the end of hostilities. In law enforcement, in the U.S. certainly, and most other democratic countries, we're rather allergic to detaining people without charge. And so I think here in the U.S. it's 72 hours. Somebody has to be charged and begin the criminal justice process or released. And that's why we have a writ of habeas corpus and so on and so forth. So those two things in and of themselves make it significant and consequential which paradigm you're in and which body of law you're applying to a given situation. And so when we talk about where does the conflict extend to, that's what it comes down to. Can one side use lethal force as a first resort and in the course of doing that cause incidental harm to people and property around? Or are they limited to force as a last resort with no conception of incidental harm to anybody around and so on and so forth?
We've got about 2 minutes left, so we'll give those over to you. Dr. Sari is the person that traveled the furthest
Can I
here.
just quickly answer
appreciate
that question by sniping back at Mike and saying that, well, the whole hybrid stuff, it's not a non-issue. And the reason why it's not a non-issue is, yes, some of the basic big legal questions that we face, conflict classification, DPH, et cetera, in a hybrid context are the same. There's nothing new really there. However, we will probably very quickly move into a situation where we will have done the clash between the human rights paradigm of right to life versus right to kill, essentially, under law of armed conflict, detention, etc., and move into a scenario where it's going to be about right to privacy, right to be about family life. And again, from a European perspective, as states which are bound by the European Convention on Human Rights, subject to the jurisdiction of the European Court, that is quite a scary prospect. Which is why, these distinction, which law actually applies, is hugely important. And these are new legal challenges. They are new legal challenges, Mike, which really do.
All right, ladies and gentlemen, thank you very much. I'll hand it back over to General Dunlap.
Well, as you can see, we wanted to put together a conference where everybody agreed with each other and we'd have this genteel discussion. What we're going to do now is, one thing that did strike me during this, and my students, poor Pete, he's heard this 1,000 times, but I think it's really important. We've talked about thresholds. We talked about the implications. I think there are two things we need to keep in mind. what do interpretations of the law do to incentivize the enemy? We always have to red team ourselves as to what we do. I think the other thing is that we as lawyers, really, if we are going to be credibility in talking about thresholds and intensity and so forth, we have to know a lot about the military. We have to know a lot about warfare. We have to know a lot about weapons. We have to know a lot about the mindset of the client, so to speak, which is the members of the armed forces or other security forces that may be the appropriate responders in a particular situation. We've gotten, and Professor Sari gave us the perfect segue into what our first panel will be after lunch when he talks about the implications of privacy and so forth. What a tremendous panel. I really, really appreciate it. Now, here's the rules of engagement here. 10:50 to 10:20, we have an extra 10 minutes in there. You have a half hour. Then you really need to be back in here for our luncheon speaker, who is different from what you saw in the program. Because Professor Farahani has a sick baby, she is going to speak tomorrow morning. Mr. Silliman, who's the VP and General Counsel of Verizon, will be speaking to us at lunch. It is a working lunch. You can be eating while he's speaking, but you have a half hour to get your lunch and get back in here. Thank you so much, and let's give this another